were not as advanced and organized as Mexican and Peruvian communities. However, many Colombian indigenous communities attained an important degree of social organization and technical development. These cultures exploited gold, emeralds, and salt, and those minerals were the base to an incipient economy. So, as cliche as it may sound, it is not a coincidence that El Dorado legend was supposed to take place in Colombian territory. But what I would like to point out about this period is that mining was present in Colombian history since the very beginning, and that indigenous communities received an important cultural heritage that they are determined to preserve. Now let's go to the colonial period, which is the period comprehended between 1492 and 1820. During this period, the main export product was gold and other metallic minerals that were used for minting coins. The subsoil and the minerals belonged to the Spanish crown, and a royalty was owed to the Spanish crown, which corresponded to a fifth of the minerals produced. That's why it was called the royal fifth. During this period, the indigenous communities were used as workforce, and later, people from Africa were brought in order to undertake the most difficult tasks, such as mining exploitation. What is important about this period is that mining was not only present, but it was the base of Colombia's economy. And that since the colony, Colombia received under its roof many cultures and races, which make this country a rich country and a very interesting one. Now we go to the period of the First Republic, which is the period comprehended between 1820 and 1886. During this period, the institutions from the colony were just transferred to the Colombian Republic. So ownership of subsoil was transferred from the Spanish crown to the Colombian Republic. This period was characterized by a political instability and by internal fights, due mainly to the choice between a centralized system or a federal system. During the 19th century, the federal system was winning this battle, and that's why during many decades of the 19th century, subsoil ownership was in the province's heads. It was only until 1886, with the enactment of a new constitution, which ruled Colombian destinies from 1886 to 1991, that the property of the subsoil and of the minerals went back to the central government. And this constitution also established that Colombia was a unitary republic, it chose a centralized system, and it divided Colombia in provinces, and these provinces in municipalities. Here you can see a map of Colombia today, where the provinces are shown. And what I want to highlight here is that the current political division is not very different from what it was in 1886. During this period, many provinces were powerful, and they had fights because they wanted to control the economy. One good example is a fight between Antioquia's department and the Cauca department to control the exploitation of gold in El Chocó department. What is important about this period, or what I would like you to remember about this period, is that the centralized system may have won the battle back in 1886, and then again in 1991. But Colombian provinces and municipalities have always had a certain degree of autonomy and independence, and they want to keep it. And that's one of the challenges of mining nowadays. Now, let's go to the years of government intervention, which is the period comprehended between 1973 and 1991. This period was characterized by an active intervention of government in subsoil studies. And these studies were aimed to attract foreign investment to the country. As a result of these efforts, the Cerrejón project in La Guajira was developed as well as the Cerro Matoso project in Córdoba. However, during the 70s and 80s, most of the foreign investment was attracted to other Latin American countries such as Peru, Chile, and Mexico, mainly due to a lack of a solid legal framework. Colombia's government was aware of this void, so it decided to enact a new mining code in 1988. However, these efforts of Colombian government were not enough. And they were not enough because Colombia was about to change. And it was about to change because Colombia was getting ready to an open up of its economy. So this opening of Colombian economy, which impacted every aspect of Colombian life, was also concurred with the enactment of a new constitution in 1991. And this constitution was drafted by a constituent assembly, which was integrated by 70 members belonging to different political affiliations. So the traditional political parties got therein represented. The former guerrilla groups were represented in this constituent assembly. And of course, the indigenous and Afro-Colombian communities also obtained representation. So the constitution that they drafted was an ambitious one. They wanted somehow to correct the mistakes of the last 5 centuries. But can you imagine that? Try to correct 5 centuries of mistakes with one constitution? Of course, it was a difficult task. So that's why they included a special protection for indigenous and Afro-Colombian communities. For the first time in a constitutional level, the environment was protected. They decided that Colombia was going to be a unitary and centralized republic, but that the autonomy of the provinces and the municipalities was going to be respected. They decided that the state was the owner of the subsoil, and they appointed the state as director of the economy. So all these positions, ideas, and hopes were reflected in our current constitution. So it should not be surprising that some tensions arise when you're trying to apply or to the rights protected by this current constitution. And finally, we have the period that I called the mining blossom. I know that some of you are going to say that I'm a little bit exaggerated, but the truth is that's the way I have seen the mining process in Colombia, and that's the image that I want you to keep at the end of this legal mining tour. So the legal frame that was given by the Constitution prepared everything to the enactment of a new mining code in 2001, which is the mining code that we currently have. And the purpose of this mining code was, again, to attract foreign investment to Colombia. In line with that goal, during years 2006 and 2009, many tax incentives were granted to the mining industry in Colombia. And then in 2010, President Santos determined that mining was going to be one of the engines of Colombia's economy. And you know something? It worked. So finally, Colombia was attracting foreign investment. Everyone was interested in Colombia. We were a hotspot. However, the mining institutions were not ready to receive all the mining applications that they received. The communities were not ready to understand all the changes that mining was going to bring to their day-to-day activities. And let's face it, some of the first companies that arrived into the country did not understand Colombia's culture. Maybe they were told or they read Colombian constitution and they concluded that Colombia is a centralized government, which decisions are taken by the central government. However, because of history, that's not the way it is. And many factors must be taken into consideration. So all these led during years 2010 to 2018 to social movements that ended up in the amendment of the mining code in 2010 to include additional protected areas, to popular consultation processes to bind mining activities. It led municipalities to use the decisions of their corporate bodies to bind mining activities, and it was kind of messy. However, I think that now we're going towards balance. And Constitutional Court recent decisions make me believe this statement to be true. Of course, we do still have challenges on the horizon, such as giving a real framework to prior consultation processes to decide how, when, and how important is going to be the intervention of municipalities in the decisions related to mining, and to show to the communities that it is possible for mining to respect the environment. But I think that we have already learned from our mistakes. And I think that this country is ready to discover if El Dorado was just a legend. So after this brief walk through Colombian history, we have arrived to the second stop of our little mining tour, which is mining law factors to enter into the Colombian market. This stop was divided in 3 different stops: the constitution frame, the mining code frame, and finally, tax incentives. Regarding the constitution frame, I would like to emphasize 4 points that I think that are key to understand the roadblocks that mining has faced during the last decade in Colombia. Those points are: Colombia is a unitary republic. The state is the owner of the subsoil and of the minerals therein. Colombia gives a special protection to indigenous and Afro-Colombian communities. And finally, Colombia's constitution is called the Green Constitution or the Eco-Constitution. So, as I have already mentioned, the purpose of this mining code was again to attract a foreign investment to the country. So that's why the mining code establishes that foreign individuals and entities should receive exactly the same treatment as Colombian individuals and entities. And Colombian governmental regulatory bodies are expressly prohibited from requiring additional requirements than they would require to Colombian individuals or entities. It is also important to highlight that according to Article 13 of our mining code, mining is considered as an activity for the general pursuit of the public benefit. And I'm mentioning this qualification not because it sounds good, although it does, but because it has consequences in 2 elements that are key to develop a project. And those things are expropriation and easement. So thanks to this qualification, the mining code establishes that easements in Colombia are legal or mandatory, which means that they do not need to be requested before a judicial or an administrative authority to impose. Furthermore, the landowner of land in an area where a mining project is located is not allowed to oppose to the imposition of an easement. So the intervention of an authority is required because it is always possible to get to an agreement with the landlord, and which in this case, the authority will be the mayor of the municipality in which the mining concession contract is located, will only be required to calculate the compensation or amount due to the landlord. Unlike what happens with oil industry, the mining code does not have a description of the proceedings that a title holder should follow before the mayors in order to get this amount defined. It only gives a few criteria to determine the amount of the compensation. This void may lead to some problems in practice to try to involve a mayor in this process. However, it is just a matter of being creative, and it does not mean that you're not going to be able to impose your easement. Also, because of this qualification of mining, it is possible for the title holders to request to the mining authority to expropriate areas that are required to undertake mining activities. Of course, it needs a prior indemnification to the owner. And now we got, then we have the special protection to the ethnic groups. So Colombia gives a higher protection to Afro-Colombian and indigenous communities. It means that if a title holder is interested in carrying out a project in an area which is covered, which is inhabited by one of these ethnic groups, it will be necessary to do it respecting their culture, integrity, and even more, it will be necessary to have them involved in the decision-taking process. Also, Colombia is signatory to the Indigenous and Tribal Peoples Convention, which means that prior consultation processes are mandatory whenever there's a project that could affect directly or indirectly any of these communities. The problem that we have right now is that the rules to perform the prior consultation processes are not yet defined, and they correspond to judgments of the Constitutional Court. So I think that this is one of the challenges, not only for the mining industry, but for other industries that may affect indigenous and Afro-Colombian communities with their activities. And finally, Colombia's constitution is defined as the Green Constitution or the Eco-Constitution. And it was because this constitution goal, or one of its goals, was to protect the environment. And we Colombians have the right to a healthy environment and to be involved in the decisions that could affect the environment. So the Constitution created many mechanisms for the communities to intervene in the decisions related to environment. There are hundreds of scenarios, and when I say hundreds, I'm not exaggerating. There are hundreds of scenarios where communities can be involved in processes aimed to protect the environment. So to take decisions with all these stakeholders is sometimes difficult. But I think that to understand it, and by giving to everyone a place in this decision-taking process, companies are in their way to succeed. So now we got to the second stop of this part of our tour, which is the mining code frame. So I divided this part of the tour in three parts. First, I'm going to address the purpose and special protection to mining. Moment. I'm sorry. So now we finally got to the concession contract. And under our current mining code, there is only one type of mineral tenure. And that mineral tenure is a mining concession contract. The current mining concession contract comprehends the exploration, the build and construction, and the exploitation stage. Mining concession contracts are granted for periods of 30 years, which could be extendable for another 30 years period. However, these extensions are not automatic. It is necessary to demonstrate to the Colombian government that it is good for the Colombian government to grant this extension of the mining concession contract. So it is even possible for the Colombian government to negotiate for better conditions than those that it initially had in the first contract. So the mining contract has an exploration stage, which could last for 3 years, counted as from its registration date. It could be extended 4 times of 2 years each for a maximum duration of 11 years. And then you have the build and construction stage, which lasts for 3 years, counted as from the termination of the exploration stage, and it is possible to request for an extension of 1 year. And finally, you have the exploitation stage, which is the remaining time of the concession agreement. During the whole life of the mining concession, the title holder will have reporting obligations, environmental obligations and permits, insurance policies, financial obligations, and finally, technical obligations. Those obligations will vary a little depending upon the stage in which the title holder will be. However, the time is short and it is not possible to talk in detail about this right now. So, how do you get or how do you obtain a mining concession contract in Colombia? So one way to do it is to file a mining application with the mining authority. And at this point, I would like you to bear in mind that the current application system used in Colombia applies the rule first in time, first in right, which means that the mining applications that were filed before must be evaluated before the mining applications that are filed afterwards. To file a mining application does not grant the title holder, the applicant, any right other than to have this application evaluated. The only way to have right to explore and exploit Colombia subsoil is to have a mining title duly registered with the mining registry. The process that I'm going to explain is a simple one in theory. However, in practice, it is not always easy to determine how long is it going to take for a mining application to become a mining concession contract. So maybe that's why, and this is a parenthesis, many mining companies decide to look for mining concession contracts already granted. And here they will encounter another different problem, but one of the usual problems that they encounter is that the exploration stage has already expired. In these cases, the integration of mining concession agreements has proved to be very useful because it allows the title holder to choose the stage in which he wants to start his mining concession contract. So now, closing the parentheses, let's go back to the steps that must be required to obtain a mining application in Colombia. And I would like to highlight that these steps that I'm going to mention right now were not included in the initial wording of the mining code, but they were the result of social pressure and further decisions of the Constitutional Court. So the first step is a clear example of what I'm saying, and it is the agreement with the municipalities. The purpose is to have these agreements included in the land management plan of the municipality. This land management plan is a document in which the municipalities decide how to organize the soil within their territory. During this stage, the mining authority, which could be the National Mining Agency or Antioquia Secretary of Mines, and I don't know if you remember that when we were talking about the First Republic, I said that there were some provinces that were very powerful with, well, Antioquia was maybe the most powerful one, and it has an important mining tradition, and I think that the most important gold projects are located in that province. So the mining authority has a meeting with the mayor and his or her team, and during this meeting, the mining authority is supposed to show, based upon prior studies, such as geographical studies, environmental studies, studies taking into consideration the mining applications currently in place and current mining projects, to explain to the municipality which is the mining potential of the municipality and how does a mining concession contract work. The purpose is at the end for the municipality and for the mining authority to decide together which percentage of the municipality is available to undertake mining activities. Then you file your mining application. And once you file your mining application, the first thing that the mining authority is going to do is to declare the free area. And to declare the free area is just to say which areas are available to grant a mining concession contract. And in this evaluation, the mining authority is going to take into consideration the application filed before, the mining concessions already granted, and the areas in which mining activities are prohibited. Once the mining authority has determined the free area, it will call the title holder to see if it will accept the area. And if the title holder accepts the area, then the mining application will go through an evaluation process that will have three stages. It will go through a legal, technical, and financial evaluation. And if everything is good, then there's going to be a meeting between the title holder and the National Mining Agency, and then a public hearing will take place. And during this public hearing, the title holder, the municipal authority, the environmental authority, the mining authority, and all the interested people will intervene. This is also a requirement that was included by the Constitutional Court's judgment. And finally, if everything goes well, you can sign your minute of your mining concession contract, and then it is sent to the mining registry to have it registered. So there are different ways to acquire a mining concession contract. So if you want help, please call us. And the last point that I'm going to mention regarding our mining code is the point referred to areas in which mining activities are restricted. And this is a picture of the Santurban Páramo. Of course, in Colombia, there are some areas of its territory in which mining activities cannot be undertaken. This has been a very sensitive matter, and there have been social movements that have led to amendments of this point. So, per the initial wording of the mining code, mining in Colombia was prohibited in national and regional parks and in forest reserves. Regarding the forest reserve areas, the mining code established that if a title holder was interested in undertaking mining activities in a forest reserve area, it was necessary for the title holder to request to the relevant environmental authority an area extraction. So remember that the mining code was issued in 2001. But later, around year 2008, 2009, there was a company that announced to the public opinion that it was ready to file the environmental impact study to obtain its license in order to undertake a mining project in an area usually considered as páramo or moorland. And I say usually considered because at that time, it did not exist any criteria to determine whether a certain environment could be considered as páramo or not, other than hate. So this announcement produced a social movement without precedent in Colombia that finally led to the amendment of the mining code in 2010. It was not the only reason to have the mining code amended, but it was one of them. And in this amendment, the areas restricted or where mining is prohibited were extended to protective forest reserves and to wetlands. However, this amendment found two problems in its way. And these problems were, the first, that in Colombia, the boundaries of the páramos were not defined. Many of the boundaries of some páramos are not defined yet. And that the law, which tried to amend the mining code, was declared non-constitutional by the Constitutional Court due to lack of prior consultation. So the government was already aware of the need to protect this environment, so it tried to include some articles in the same sense, a little bit nuanced, in two national development plans. And finally, the last one, which was issued in 2015, was also declared as non-constitutional by the Constitutional Court. So, long story short, currently in Colombia, the areas in which it is not possible to undertake mining activities are national and regional parks, protected forest reserves, moorlands, and wetlands. And last, because I want you to leave this tour with the certainty that Colombia is a great country to invest, I'm going to give you a list of the tax incentives that mining could receive in Colombia. There's a tax incentive for foreign direct investment in mining, which could benefit from a tax refund certificate, which is granted to companies increasing their investments in mining exploration activities. There's an incentive to machinery import. There's an incentive to mining exploration. It is possible to do public works in lieu of taxes in areas affected by the armed conflict. And finally, there's a 25% incentive to companies investing in environmental protection. So we finally arrived to the last stop of this little mining tour, which is mining in times of COVID-19. And I'm going to address the government's response, the impact of COVID-19 outbreak over the mining industry, and finally, the main challenge. So as expected, the crisis created by the outbreak of COVID-19 impacted every aspect or every economic activity in this country, including mining. So on March 12th, just a few days after the first case of COVID-19 was confirmed, the Ministry of Health declared the health emergency, which allowed this minister to issue or to undertake special administrative measures in order to avoid the spread of the virus. This health emergency will be in force until August 31, 2020. Based upon this health emergency, on March 17, the national government declared the economic, social, and ecological emergency, which allows the president to take special measures in order to face the crisis. Also, since March 10, the government promoted social distancing. So, as a consequence, all social activities and non-essential economic activities were put on hold. What is going on right now is that Colombia is under general lockdown. However, progressively, some activities are going back to the productive life. Here, it is very important to point out that since the very beginning of the crisis, mining activities were excluded from the isolation measures, which in theory means that mining companies were allowed to continue with their activities business as usual. However, at the beginning of the crisis, some companies found some resistance of their employees and of the municipality and of the municipal authorities. However, I think that those inconveniences are already overpassed, and most of the mining companies are just working business as usual. Also, with the aim to prevent the spread of the virus, the health ministry issued some biosafety protocols at the beginning, general biosafety protocols for all the sectors of the economy, and then one specific for the mining sector. And I feel proud to say that the protocols adopted by the mining industry are being used as an example for the other industries that are going back to the productive life. So, what was the impact of COVID-19 outbreak over the mining industry? First of all, let's talk about the authorities. So, since the beginning of the crisis, the government encouraged the Colombian regulatory bodies to use telecommuting whenever it was possible and to avoid on-site attention. So, taking into account these recommendations, both the National Mining Agency and Antioquia's Secretary of Mines stopped their on-site attention, and they have been providing their services online. Also, both entities granted a term suspension for some administrative proceedings. So, what happens with the obligations under the mining concession contract? As I have already mentioned, the mining activity has been exempted from the isolation measures since the very beginning of the crisis, which means that for the National Mining Agency and for Antioquia's Secretary of Mines, the COVID-19 outbreak itself cannot be considered as a force majeure event. So, title holders must be complying with their obligations under the mining concession contract. However, it is important to bear in mind that our mining code has two scenarios according to which it is possible to the title holder to request for a suspension of their obligations under the mining concession contract. And those scenarios are force majeure events, which are contemplated in Article 52 of the Mining Code, and decrease of the production of the activities, which are contemplated in Article 54 of the Mining Code. So, regarding the force majeure events, what the National Mining Agency officers have told us is that the COVID-19 outbreak is not going to be considered as a force majeure event. So it will be necessary for the title holder to demonstrate that there were unforeseeable and irresistible circumstances that hindered compliance with its mining obligations. And regarding the authorization for production decrease, the National Mining Agency has said that they're going to make an analysis case by case, and then the title holder will have to demonstrate that it was going through specific circumstances that impeded the title holder to continue with its mining activities as usual, or no me están oyendo? And okay, and these challenges are two. Well, there are many challenges, but I'm just going to talk about two. And I think those challenges are the performance of public hearings and the prior consultation with ethnic groups. So, as I have already mentioned, as a result of some decisions of the Constitutional Court, in order for the mining authority to grant a mining concession contract, it is necessary for the mining authority to perform a public hearing. So, what the president of the National Mining Agency has been telling to the public in general is that the National Mining Agency is going to try as much as possible to implement a mixed system, a little bit of presence, a little bit of virtual means. However, in a country like Colombia, where many municipalities have really limited access to internet, I think that's going to be a huge challenge for the mining authority to put this in place. But definitely, it's something that they will have to tackle in the near future, because otherwise the granting of mining concession contracts is going to be suspended for a long while. The other main challenge will be the performance of prior consultation with ethnic groups. So also, as we have already mentioned, every time that a project is going to impact one ethnic group, it will be necessary to undertake a prior consultation process. And these prior consultation processes usually involve a lot of meetings, because those meetings are necessary for the applicant to show to the community the project, and for the applicant and for the community to reach to agreement. So in view of the social distancing, the Ministry of Internal Affairs issued a memorandum encouraging the use of virtual tools to continue with the prior consultation process. However, a few days after the Ministry of Internal Affairs issued this memorandum, the Public Ministry issued another memorandum warning that the execution or the developing of these, or the performance of these meetings using virtual means could endanger the rights of these communities to being consulted. So as soon as the Ministry of Internal Affairs saw this memorandum, took back its initial memorandum. So currently, we don't have clear rules about whether it is possible or not to perform these meetings using virtual tools. However, taking into consideration the former positions of our Constitutional Court, which have been very protective towards ethnic groups, our advice is to wait until face-to-face meetings are possible. And this is the end of this Colombian legal mining tour. Thank you for being here with us today, and we are open to questions. Thank you.
Angela, thank you. Thank you so much. Your presentation was really, really nice, very interesting. And we have received so far a couple of questions. Due to time constraints, we handpicked just three of them because it is almost 10 o'clock. So please feel free to jump in to answer the questions if you want. But the first question is basically, do you think that legal stability exists in Colombia? Okay, that's it. This is a tricky question for a Latin American country, but I certainly believe that yes. There's legal stability here. The mining code has almost 20 years on the one hand. On the other hand, Colombia has been a democracy almost all the time since its independence from the Spanish in the 19th century. We have had just two dictatorships in all the republican life of Colombia. There has not been any expropriation movement, any attack to the private property in the institutional life of Colombia. And even though it is not perfect, and I know that it is not perfect, and some of the participants that are listed in this webinar that are friends of us, to all of them, a warm hello. Um, uh, the bottom line is that Colombia has been respectful of the private property. Again, it has not been perfect. Colombia is facing some lawsuits in the international arena because of that, and I think that it will help for the Colombian government to learn that it has to be as protective as possible of the rights of the individuals and of the foreign investors. So I believe that the answer is yes. The second question that we receive here is the following, and let me read this. If I have an option over mining applications, how do I ensure that once it is converted into a mining title, the applicant is really going to complete the assignment agreement in my favor? Okay, this is a very good question, a very common one. And again, Angela, if you want to jump in and help me, it would be great. As you may know, mining applications cannot be assigned, only concession agreements, and therefore, if you enter into an agreement with a mining applicant, it is necessary to ensure that once the mining application is converted into a concession agreement, the concession agreement will be assigned properly as agreed between the parties. So what we have done is basically to prepare a promise to assign between the two parties. And the reason why we prepare these promises to assign is because the judges are quite familiar with this type of contracts, and therefore the enforceability of these promises of assignment uh, are easy. I mean, not 100% guarantee, but they work. And also, in addition to these promises to assign, we also um, ask the mining applicant to grant our client a power of attorney and a irrevocable power of attorney in order for our client to undertake all the necessary proceedings to assign the concession contract when this concession contract is granted. So those are basically the mechanisms that we have used in the past and nowadays in order to secure the assignment of these concession agreements. Okay, here is a third one. Um, is it advisable to buy the shares of a company owning a mining title? Okay. Yes, 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 and no. Of course, if you purchase the company, if you buy the shares of the company that holds the mining title, you avoid all the proceedings necessary to be undertaken in front of the mining authorities, which is good, which is always good, because mining authorities, unfortunately, are not as fast as they should be. But purchasing the company, you are assuming the liabilities that company has, and therefore there are certain risks involved in the purchasing of the company that, of course, you can prevent them by means of a due diligence um, activity, a due diligence report, but they are not 100% preventable. The other alternative, I mean, to purchase just the mining titles, has the advantage that it avoids you the assumption of liabilities from the company that sells the mining title, which is not 100% true, but it is almost 100% true. And but you have to undertake the process of assigning of the mining title in front of the mining authority, and that can take a bit of time. What you need to do is to be patient, and of course understand that it takes time, and definitely patience. I think that okay, so it is 5 minutes past 10. So I don't know, Angela, if you want to say some last words. I really thank you all I really would like to thank all the participants. Thank you for being here with
No,
us.
thank you.
It's been a pleasure for your time. And again, if you have any additional questions, please let us know. Our email addresses are here on the screen. And if you don't have time to copy them, please go to our webpage and you will find them there. Again, thank you so much.